Well, thank you so much, Jim. I appreciate the opportunity to be here tonight. What a wonderful community you have. What a beautiful facility you guys have. And thank you so much for allowing us to come and spend some time with you tonight. Some of you may remember, we actually were back here in 2019, Jim. And you know what? A lot has changed in the world since 2019. Is that right? I don't know about you guys, but it seems like since 2019, we've just kind of hit the fast forward button in life. And so much has changed. Technology has changed, finances has changed, the world has changed. And all those changes impact your estate plan. And those are going to be some of the things we're going to talk about a little bit tonight. But the main focus of our conversation is going to be about probate. And I'm so honored to be here tonight with my colleague and my friend, Ashley Palmer. Ashley and I have worked together, how many years now, Ashley? 8, 9, 10, it all blurs together after a while, right, guys? But I can tell you that there is no better estate administration probate paralegal in the state of North Carolina better than Ashley Palmer. She's not only a paralegal, she is also a CPA. She has on her business card something called CIA, which makes me a little nervous, as y'all know the term, I'll be honest. I think that stands for Certified Internal Auditor, is that right? Okay, I'm hoping that that's what it is. But y'all, we are glad to be here tonight. We're going to be happy to entertain any questions that you have, not only about probate, but also about estate planning, because those worlds intersect. We have a lot of cookies in the back. We have a lot of water, Jim. So if you haven't had an opportunity to grab a cookie, if you haven't had an opportunity to grab some water, feel free to do that. But I'm going to turn the podium over to my colleague, Ashley Palmer. And also, we have some cool handouts here that we're going to be passing out for you. We also have our business cards. If this is something that's relevant to you, if this is something you think perhaps is going to impact your family or your finances, I'm going to invite you tonight to take one of our cards and let's follow up and let's have a little bit more detailed dialogue on these subjects. So, without further ado, Ashley Palmer. Ashley.
Testing, 1, 2, 3. How does it sound? Yes? Okay. I want you to tell me if it's too loud or not loud enough. All right? We did the mic check beforehand, but just want to make sure it stays good. Yes? All right. So like I told the wonderful people, I want to thank the people who helped the tech set up tonight also. They were really great. But once I told them that I've been a dancer my whole life and I'm a performer, then they were like, okay, it's fine. All right, let's get started. So this is Probate 101 by me. And, well, just a little bit, is it okay if I share a little bit more about myself? Okay, besides being a dancer. Let's go back in time. It was Christmas Day, 1985. I was 7, my sister was 4, my mom was 35, my dad was 38. After we opened presents, my mom had to tell us some very sad news that our father and the love of her life had passed away early in the morning after a 2-year battle with cancer, a kind that is fortunately now curable. Her bank accounts were frozen. She had never written a check to pay a bill because Dad handled that. The advisors in her life, like lawyers, CPAs, and financial planners, were key in helping her to have the mental wherewithal and resources to raise us and send us to college. A few years out of college, I kind of fell into this job at another great firm. I just knew someone there, and I liked it, but I thought it was a dead-end job, and I was young and upwardly mobile, and I wanted to be CEO at the time. So I quit to go back to school to get my master's in accounting and become a CPA. I went to UNC, go Heels. I did the audit gig for many years, but I always remembered my job at the law firm as the best job I ever had. And the reason is because I felt like I was making a difference for people when they're going through a difficult time. And there wasn't really any helping or making a difference for people as an internal auditor. So Even though some of my audit clients said they like to see my smiling face coming, mostly everyone just dreaded seeing us. So 10 years later, almost to the day, I went back to that same job at the same firm. And now I've been doing this work for almost 12 years. And I love using my quantitative skills to help people through one of the most difficult times in their life, the loss of a loved one. And I feel it's my calling and mission in life to help relieve the burden of probate paperwork from grieving people. So that's my why story. That's why I do what I do, and that's why, even though sometimes, it's a lot of paperwork, it's a lot of phone calls, it's a lot of on hold with, the financial institution or whatever, I'm helping people so they don't have to do that. So that's why I really like what I do. So does anyone just have an idea of what probate is? Okay, anyone not have an idea? So it's the process of proving or validating that a person's will is their one and only true will, meaning they made it, and it's valid, meaning the most recent. And this process is a court-supervised process conducted in the county where the deceased person lived. So for here, I believe it's Durham County. Okay? Yeah. So we have a Dilbert cartoon here about estate planning. So you can avoid probate costs by creating a living trust, says the lawyer. Dilbert says, so I can use an inconvenient system created by lawyers to avoid a worse system created by lawyers. The lawyer says, according to my watch, that witty observation just cost me $4. Got that right. Dilbert. It's a complicated legal process most people don't know anything about until they're named someone's executor or end up being nominated as the personal representative of a loved one's estate because if that person didn't have an estate plan. And there's another funny cartoon. Dad says, I'm sure you can trust you not to fight over my money when I'm gone. And they all say, of course, and they have weapons in their hands. Right? So we certainly see a lot of fighting beneficiaries. So going through probate can be compared to going through customs at an airport. So I want you to think about that analogy. Like customs, probate is a legal process set out by the government. Getting to your vacation is like getting your inheritance. And probate is how the decedent's assets get to the person to whom they are entitled. So all of the items that you bring with you, just like when you're traveling, your suitcases go through the TSA scanners, right? Everything that you bring with you is scrutinized. And like in the estate world, that means the assets in the estate are inventory. So you only bring what you need, the assets in the sole name of the decedent, nothing more. So you don't want to put assets that pass by beneficiary designations or aren't in the decedent's sole name. And generally, we don't want to add things to it. We want to just keep it as streamlined as possible and not put things in the estate that don't have to be there. So you have to carry your own bags, i.e., only bring what you need. So I'm like your travel agent through this process. So I help guide you to what I've seen people do that's good or not so good in the past. I certainly keep you within the rules of the laws and the IRS and all of that. And I'm here to help you navigate the process, but I can't travel for you unless you want me to take the trip for you. And what that means is sometimes in a case where there aren't many family members left, no one's basically left holding the bag. Sometimes there are those scenarios where people don't have family, then we can be the personal representative of the estate in certain circumstances. All right, so the nitty gritty. So this is an outline of what we're going to cover today. So first, we need to determine the type of estate we're going to do. There are multiple different kinds. There's a full estate, a small estate, summary administration, which is only for a surviving spouse. The surviving spouse gets all the assets, but they also get all the debts. It's not always attractive. There's a spousal allowance if it's below a certain amount, 20 to 60, well, it's about $60,000 for that. Vehicle only, the vehicle can only be $5,000 or less, and there can be nothing else in the estate. So for purposes of today, I'm only going to cover the full estate, because once you kind of know the full process, everything else is just almost a subset or an abbreviated version of the full estate. So today we're talking about the full estate. So we qualify as the personal representative of the estate. We file the will. We ask the court, we apply to become the personal representative. And I'm just going to skip ahead real fast so we can define personal representative. So if there's an executor, then if there's a will, then there's an executor, and that's the name of the personal representative. So think about the personal representative up there at the top as an umbrella term. So you might hear me say PR, that means personal representative. That covers the executor. If there's a will, that means it's testate. Or it's an administrator if the person did not have a will, and that's called intestate. So will, executor, testate. No will, administrator, intestate. All right, let's go back. So first we have to get qualified. So, when someone first passes away and you were maybe their power of attorney, well, that power of attorney is no longer good, but no one's qualified yet because no one's applied at the probate court yet to become the PR of the estate. So there's always that, probably a few weeks or a month of kind of in-between time where no one's really authorized to handle the deceased person's assets yet. And then we publish the notice to creditors. That is an ad that we run. It runs, like for example, if we started on June 1st, it would expire on September 1st, so it's 3 months. Creditors have 3 months in which to present their claims against the estate for payment. But once that runs, then all other claims are forever barred. So it stops the clock on anyone coming after the estate's assets. And then about that time, when the notice expires, we do a 3-month inventory. So we inventory all the assets of the estate as of the date of death. So, and then we marshal all the assets. So we might have to change locks on the house. We have to go to the bank and close bank accounts and put them in the name of the estate. We transfer vehicles that might need to be transferred, or at least get the keys to the vehicles, possession of the assets. And then really I would say some of the most important things we do are filing outstanding tax returns and resolve any tax issues, pay creditors, claims, and costs of administration. So a lot of people, they get qualified and they're like, okay, I have all this money and now I want to distribute to the heirs, but we have to pay the taxes and the creditors first, right? They all have to be satisfied before anyone can get their inheritance. So that's the last one, is distribute assets to the heirs. And at the same time, basically, we will submit annual accounts until the final accounts can be filed. How's the volume? Too high? Too low? Good? Awesome. Thanks. So we would do an annual account if we haven't been able to resolve all the tax issues and pay all the creditors and get everything sorted, maybe settle litigation or sell a house or something. If we haven't done all these steps, then we're not ready to file the final account. All right, so qualification, and again, we went over the PR, executor and administrator. All right, so what does it mean to qualify? So we submit what we hope is the original will to the probate court. They will look at it, examine it, make sure it is an original and not a copy. They don't like copies, it's a whole other process and a lot of other forms. The witnesses have to be called in if it's a copy. So copies are, I'm not gonna say no good, but it's just a lot of work. It's a lot of extra hassle. All right, so the court is the one who names the executor. So when you put executor in your estate plan or in your will, you're nominating that person. That person may not be the actual person that serves based on the court's judgment. So things like, if you've ever declared bankruptcy or have a criminal record, then the court doesn't want you to be the executor of someone's estate, right? That makes sense. And so adopted children have the same right to inherit as biological children. Adopted and biological are the same. Stepchildren are not the same. Stepchildren are essentially no relation or like friends. So if you're in a blended family, you want to make provision for that, you definitely have to do that because they're otherwise not going to be included. And then if you know of or are in a blended family situation, if people are fighting, it's just going to cost more. So whatever you can do with transparent communication ahead of time is usually better than when tensions are high after someone passes, because it just gets to be expensive. So we give the personal representative a letter upon qualification with all of their specific deadlines it's all based on the date the person passed and the date the PR got qualified. So all the deadlines, all the tax and court deadlines are based on those two dates. And so we spell out what those dates are, and we have a post-qualification meeting where we go over the letter upon qualification, which is the most substantive meeting that we have with our clients, where we basically give them all the directions of what they're supposed to do in administering their loved one's estates. So it just outlines all the duties and what to expect. Notice to creditors. So this is one of the most important things the most important steps. Because like I said before, after 90 days, creditors are forever barred from submitting claims. The PR can deny claims if they're late or contest them if they believe them to be invalid. And running the notice is not only important, but required if real property is to be transferred within 2 years. So let's say, husband passes away, all the financial assets were all joint, automatically passed to the spouse. But let's say he owned the house by himself. So if that is going to be put into, if she needs to sell the house and it was in his sole name, she's got to run the notice if it's to be sold or transferred to someone else within 2 years. And actually that happens more when, it's like the second parent to pass away, then the kids want to sell, need to sell their parents' house because no one wants to live there. And so you have to run the notice, even if you don't have any other assets that have to go through probate. If you want to sell that property within 2 years, you have to open the estate and run the notice.
First, I don't think you're able to file the newspaper ad until you figure out all the creditors. For example, if you've got undermaterialized medical expenses that may or may not.
Who's speaking?
First of all, it looks like you can't begin the probate process until you can determine who the creditors are. For example, if you have a series of medical bills, but you don't know if insurance is going to pay or Medicare is going to pay, but until you determine what the debts are, you don't know what they are. Same thing if you're in the middle of the year and you haven't filed a tax return because you don't know what the tax liability is. You don't know if you're going to get a refund, you don't know if you're going to have a liability. I would assume that tax return also would include 1041 for the state liability.
That's correct.
I did have another question too, if you don't mind. The notice about, I call it immovable property. Can it be sold during administration by the executor or the administrator without having to wait until the creditor notice is there, so long as you put the funds into an estate account?
So is your, that was a lot there. So is your question, can the PR sell the property
Yes.
before the end of the notice?
Yes, and PR sell the property, put the proceeds into an estate bank account pending the determination of the outcome of the payment of the debts and claims of creditors.
So,
Because what you're doing is you're substituting and paying a movable property asset for a liquid asset.
right. So it depends, which is every professional's answer, right? So it depends on if the PR is the executor and if the ability to sell the property was specifically granted to the executor in the will by the testator. If it was, then they probably can sell it, but they do have to, it's not that the money has to go into an estate account per se, it's just that those claims must be paid somehow, right? So the claims must be satisfied. Generally speaking, you know, I would say in a fast timeline, when, you know, let's say someone passes away June 1st, we probably can get you qualified maybe, let's just say by July 1st, then that we get the notice running and that it's gonna expire October 1st, right? So technically speaking, the closing of a house can happen after that notice runs once. It runs 4 times for 4 consecutive weeks, and then it, you know, it gives a deadline of the 3 months. But after that notice is run one time, the house technically can be sold, but again, you can't run off with the money and not pay the creditors. Does that make sense? Generally speaking, you gotta pay the creditors off.
So that answers, but again, that's one more also. I would assume that you're not going to sell the house if there's a specific legacy of the house to a legacy. Would that be right?
Like if it's given to,
Well, they can leave the house. X, Y, or Z.
Yep.
Would not be selling the house. Would not be-
if they wanted to, they could. Those people, if the will specifies that I give my house to my 2 children, and the 2 children would like to sell the house, the notice still must be run, but the children can sell it themselves. But again, it somehow, whether there's money in the estate or out of the proceeds of the house, all those claims must be satisfied. Does that make sense?
Excuse me for 1 second. Jim and Ashley, and I apologize if you mentioned this in the beginning, but we typically hold questions till the end because otherwise you won't get through your presentation.
Well, it's
So I
also
just-
because of the mics.
Okay, so I just want to know what you decided to do. You're going to wait for questions till the
You
end?
wait till the end. I would love to hear your questions. Can you just write them down? And then I'll take them at the end. Is that?
Thank you, thank you.
Okay. All right, the inventory. So some things that may be included, depending on how the assets are titled, are bank accounts, individual accounts, possibly joint accounts, vehicles in the sole name of the decedent, safety deposit box, closely held businesses, real property, if there's no will and not jointly owned, sometimes the real property will be in the estate. Life insurance and retirement assets, and that I would say is unfortunate when life insurance and retirement assets come into an estate, because those really should pass to your beneficiaries just straight away without being subject to creditor claims or tax. I mean, you pay taxes on what you take out of an IRA, but it's not subject to any probate court fees or disclosure. And so generally speaking, we would recommend that you keep your assets aligned with what your family situation is. So if you acquire a new asset, make sure you have one of these life insurance or retirement, especially make sure you have named beneficiaries so they don't end up in your estate. All right, so this is fun. Potential costly issues. So we made this list. I made this list based on, I pretty much have a story about every single one of these items. Because, and we made this list and we give it to our clients to let them know that if any of these come up, or if we know that you have one of these issues already, it's going to cost more than just the standard, legal fees. So if there's litigation, obviously, people suing each other, the estate's party to a lawsuit, that's going to, certainly be expensive, and honestly, it's going to be more expensive for the litigation attorney. Our firm doesn't do litigation, but we just keep the estate running while the litigation attorney, goes to the Supreme Court of North Carolina. We had one of those cases. Family disharmony. So, people don't get along if they're fighting and they can't decide what they want to do. That, certainly factors in and costs more. Lack of open communication with heirs. I see this sometimes, or typically with men, like maybe brothers who are like working fine with me, but they aren't telling their siblings what's going on. And what happens when, in the absence of information, people make stuff up, right? So they have no idea what's going on. Mom's assets have just gone into some black hole, but if we encourage our clients to be transparent with their families, so we have that open communication, just avoids fighting and lawsuits and can be less expensive. So unfamiliarity with estate information. So sometimes, in cases where people don't have any family and we're kind of left holding the bag, we're the PR, we don't really know anything about the person, we're just trying to handle the estate and find the appropriate heirs, then, that can certainly just, you just have to search in a lot of different places to find assets and information. Assets or heirs in other states, countries, or jurisdictions. So we had an American who lived here. She moved to England and lived the last probably 20 or 30 years of her life over there, made a will over there, but had a $1 to $2 million mortgage account here that the UK people couldn't get to because the probate court wants a US person. So we qualify as the personal representative to get that asset, send it back to the UK to give to charity, like the will said. But it's just, we had to wait 4 months for the UK to get qualified first and then recommend to us. And it's just, there's stuff all over the place, people all over the place, it's just logistically more time consuming. Tax issues, unfortunately, sometimes people don't file their taxes, right? And so we have to deal with that after they pass. Or if they were involved with any fraud or potential insolvency. So that means the estate doesn't have enough money to pay its bills. So there's an order of payment of claims. It's in the statute. Taxes and funeral are near the top, and medical and credit card debt are at the bottom. But we have to pay those in order, and basically at the point at which the class at which you run out of money is, the creditors below that class might not get paid. We have an excessive or large variety of assets. So I had a client who I just kind of went with her and held her hand while she closed all of her dad's bank accounts down one street. All of the banks on one street. We just went, because there was 30,000 here and 30,000 there and 30,000 there, because that person was a child of depression, and so they had multiple accounts. So when you have multiple accounts like that, bank accounts aren't as hard as I would say brokerage accounts, when there's multiple brokerage accounts or a computer share account or an Equinity account where it's not really a managed account, it's not Edward Jones or Melody Investments or whatever, then it just gets scattered and we have to do the same paperwork 8 times, it just gets to be long and arduous. And then if there's minor disabled or incompetent heirs or beneficiaries, so as you can imagine, let's say, parents get killed in a car accident and they leave, a 15-year-old, right? And that's their only child. The 15-year-old owns the house, but the 15-year-old can't do that, right? So they get a guardianship. So then someone has to get guardianship over them and manage that house and sell it if need be, and then hold those proceeds until that person turns 18. So, and then if they're, disabled and they're getting Social Security, disability, then if they get a big inheritance, that might disqualify them, right? You can't have over a certain amount of assets, so we just have to be careful about that. So, make sure you write down your questions. I'm a performance piece entitled The Probate Experience, and it's a man chained to the wall. So, sometimes how it feels like. All right, closing the estate, everyone's favorite part. So once we have evaluated and paid all the creditor claims in order per the statute, and we filed outstanding tax returns and resolved any tax issues, and we've done any other outstanding tasks like resolve litigation, sell assets, then we can distribute assets to the beneficiaries, and we file an annual account until we can file the final account. So this is kind of probate activity timeline. So at first we get the person qualified, we submit the qualification, and depending on what court, it could take 1 day to 8 weeks to get qualified in different counties in North Carolina. Durham's currently at about 2 to 5, I think, 2 weeks, 2 to 5 weeks. So you get qualified, we run the notice, then 3 months later we do the inventory, and then almost a year later we do the accountings. And all the accountings the reason why they have the highest level of activity is because everything that went in or out of the estate during that year has to be accounted for. And I know you guys are the investment club, right? So I've got some financial terms for you that might make sense. These are all qualification, inventory, and accountings are all court filings. So think of the inventory as the snapshot as of the person's death, like the balance sheet. Right, so it's just the asset section of the balance sheet as of 12/31, right, as of the end of the year. The accountings are like the income statement. So that is like, the revenue and expenses over a period of 1 year, right? So we have the snapshot, and then we have over time. inventory, and then accounting. All right, so we can, provide whatever service level you would like, the kind of white glove service. We can either do these things for you or hold your hand to go to all of Dad's banks, close all the accounts, or, we can just, you can do more of the work yourself if you have more time and money, and we can just advise and make sure that all your filings are done. And make you where we are. So I think that's it for the nuts and bolts, but I think, and I want to take questions, but one other quick thing I wanted to mention before that is, I think you probably can't sit through this presentation and wonder, how can I avoid this? Is anyone wondering that? Yes, okay. So how to avoid probate. So I am not a trust planning attorney, but we have one in the back of the room, Jason. We have them on our team. I can tell you how it works from my perspective. So my answer would be trusts. So trusts are like a box that you put your stuff in, and upon your death, your stuff is in the box, not in your own name and subject to probate. We, the law firm, make the box for you, but you have to put the stuff inside. So the main way I see trust plans fail is when the client fails to put their assets in the box. So they don't deed the real property into the name of the trust. The other way that trust plans fail is that if clients fail to keep the assets aligned upon a change. So in assets or family circumstances. So maybe their plan was good until they downsized and sold their house that was in the trust and bought another smaller house, and never put the smaller house into their trust, or they get a new life insurance policy or account and fail to put the trust as the owner or beneficiary. And so we need to keep the assets aligned. We can also, so that's trusts. Another, another shorter answer is use joint with right of survivorship on vehicle titles. So you and your spouse, or you and your child, whoever you would like, you can put both of your names with JTWROS, that means joint with right of survivorship, on your vehicle titles. And then when someone passes away, all you have to show to DMV is their death certificate. And you don't have to do probate on that particular vehicle. Other less sophisticated ways that are fool's gold / gambling / Band-Aid approach are beneficiary designations. This, if you're making your kids, if you're putting them on your beneficiary designations, then that subjects your kids' inheritance to their potential divorce, lawsuits, creditors, and frankly, their bad decisions. So that concludes my presentation. I would love to take your questions, and is Mara going to walk around with the mic, or do you want 2 mics? Maybe the others.
Could you please repeat about the car? I couldn't hear you.
Yes, the joint with right of survivorship on the vehicle titles, like with DMV, joint with rights of survivorship. JT for joint, W for with, ROS for right of survivorship. You're welcome.
So you painted a pretty ugly picture of probate. What are the downsides to a trust?
What are the downsides to what? A trust? A trust plan is more expensive than a will plan, so I think the upfront cost is just more expensive. But you have a comment on that, on the downside of trust? Because that's
Yeah, thank you for that question. What are the downsides to trust? Well, I would suggest to you that a trust is going to be a commitment. Is going to be, who asked the question, by the way? Okay. It's going to be a commitment of time, because trust does take a little bit longer to set up than a traditional will. It's a commitment of money. It is going to be a little bit more expensive than, a 2-page will that came off the internet. And candidly, it's going to be a commitment to make some tough decisions, because in a trust, unlike a will, we're going to walk you through several different scenarios to talk about how your assets should be transferred to whomever those beneficiaries are, but do it in a way that is strategic. And sometimes that's a hard decision. It's not uncommon that we may meet with a client and maybe their child, or perhaps the child's spouse, they have some concerns about. They have concern about transferring wealth to their son because they're concerned about his wife. Those are tough decisions. So what are the downsides? I don't know if there is a downside per se. It just really relates to what is the client's goals.
Is there a question over
Any
there?
questions over here?
Okay, I think we had one. Yeah.
So if your house is in a trust and your kids are the beneficiaries on all your finances, that completely avoid probate.
I mean, theoretically, I would want to look at everything to make sure it's all, titled correctly. A lot of times people forget, oh, I have this one account over here, and then you have to do probate just for one account. But if it's really all in there, yeah, this should avoid probate.
So the house being in a trust, if the house, it's just the house is in the trust, that will avoid them from going to probate.
If it's a revocable living trust or an irrevocable trust, probably.
Thank you.
If all your accounts are at beneficiaries, TOD or PODs, whatever, and I understand your house doesn't go through probate if it's your main residence, what do I need a trust for?
Well, let me just take a stab at it and then you finish it. So
This is my favorite question.
the house does go through probate if it's your primary residence. Maybe that came from another state or something.
From another law firm.
The primary residence doesn't go through probate. If it's jointly owned with your spouse, that's true. But if it's not, if it's in your sole name, then it would.
Yes, if I understood your question, if your home is in just your individual names, and then you have all your financial accounts, whether they're the investment accounts, retirement accounts, life insurance, you have TOD, what's called transfer on death, or perhaps POD, payable on death. Why would you need to have a trust? You may not. It depends, right? Depends on what we're talking about. So I would submit to you, what is the value of the home? What is the value of these assets that have the named beneficiaries? By the way, how many of you work with a financial advisor in here? What is the question that every financial advisor will ask you during either your first meeting or in any type of follow-up meeting with them? Anyone know? What is your risk tolerance? Right? So I would submit to you, when you have just named beneficiaries on the accounts, what is your risk tolerance? Like, you've worked your entire career perhaps to build up these assets. What is the risk tolerance now that they're going to now just transfer outright to a beneficiary? So if I have $1 million in an investment account, and I need my son as the POD or TOD beneficiary, right? And I die, and those assets now transfer to him, and he's so excited about getting $1 million, he goes out and buys a car that's too expensive for his lifestyle. He then gets out on I-40 in that car, and he gets into a car accident, and he kills the CEO to the hospital. What's about to happen? He's going to get sued. Do we all agree with that? And what did I do? I just transferred him $1 million, right? And is that $1 million, when he now takes possession of it and he puts it into his bank account, is that now going to be protected against his creditors? Everyone in you should be going, no, it's not. That is the beauty of a trust. It gives us a better asset protection. So if we're talking about sizable assets, a trust is going to be a better vehicle, it's a better strategy for you to transfer wealth instead of just the traditional POD or TOD accounts. Does that make sense?
So I trust my kids to be very resourceful and handle it.
Yeah, everyone tells me that, right?
They have more money than I do, so I don't worry about
Fabulous.
it.
Well, again, maybe the risk tolerance for you is not, you're not really worried about it. If you transfer them money, they blow it, they go through a divorce, they go through a bankruptcy, they get audited by the IRS, no big deal. That's kind of an individual kind of decision.
All right, we'll do the next question over here.
Just a quick question, and that is, if you file your will with the county and you can't find the original that you had, would that suffice?
If you, hang on, am I on?
You file the will with the county.
Okay.
So with the will that you file with the county, it can be used if you couldn't find your original.
Well, I mean, I guess there's only one original. I mean, if you made two originals at the same time that are exactly alike, you file one with the county and you have one at home, would that work? Is that what your question is?
I'm just saying, the one you had at home you can't find.
Then the one that's at the county,
Would
yeah,
that suffice?
that would work.
That-
Yeah, if the one that you did at home is updated since that one, that might not be what you want, but.
I didn't think counties were involved at all in wills. I thought it was the Superior Court of North Carolina located in the Durham County Courthouse. Is that correct?
Where the.
Where a will could be
stored?
filed.
Yeah, the clerk's office,
Right? So
like the county clerk's office. Yep. They can be filed there for safety.
So I'm not a big proponent of clients filing their documents with the county clerk court. For a couple reasons, but the most common one that I run into is that you have a situation where you filed your will hypothetically in 2019, and then you started making changes to the will, but those changes never got to the courthouse. So now, when you pass away, we've got a little bit of a potential issue. We recommend at our firm that you keep your important documents wherever you keep your important papers, probably at home and a safe. Perhaps you allow your children or another trusted person to know where they are. But I do think we run in maybe to some issues if you're filing them. By the way, some counties don't accept them nowadays. And that's one of the issues as well. I'm not sure about Durham. We don't, again, we don't recommend that people file them, of course. I can't speak to Durham, but I don't think Wake does. A lot of the larger counties have gotten away from that.
And I mean, just generally speaking, I think your executor should know where your will is, how to get to it.
Is there any issue if one of your witnesses has deceased?
If it's an original will, no, it doesn't matter. But if it's a copy and you need the witnesses to sign saying, yes, that's my signature, then yeah, that's a problem.
Are wills drawn in another state valid in North Carolina?
Great question. Are wills that are made in other states valid in North Carolina? My mic's still good? You still hear me? Okay. Yes, it requires an extra form, and it requires that we go look up that other state statutes to see what their rules are regarding execution. So if it was executed in, like, for example, Texas, which, by the way, you can be 14. You have to be 14 and up to witness a will in Texas. I just learned that because we had a Texas will come in. So, but I had to go and say, well, yeah, according to the Texas law, these people, the will says they're 14 and up, and the statute says you got to be 14 and up. So, if it's validly executed in that jurisdiction, then yes. I mean, you can run into some problems because sometimes they don't have all the language that we want to have. It's better, I think, in general, to have a will in the state where you live.
I'm sorry, but I have 3 questions. First of all, are you a lawyer with purpose? Lawyers with partners? Partners with purpose?
I'm not familiar with that. Lawyer with who?
Partners with purpose?
I'm not familiar with that. Is that an organization?
Okay. The other one, I have 2 questions on your slides. The TOD, why would TOD bank accounts come into probate?
So if the beneficiary is deceased, so.
If the TOD person was deceased?
Correct.
Okay.
Yeah.
The other one is the house can't be sold within 2 years if the notice is not run? I don't
Correct.
understand that.
Correct. So I'll just go with, mom is the, second spouse to die. She has 2 children. The house is in her sole name. And basically in order to get it out of, she can, in her will, she can say, I want my 2 children to have the house. The 2 children can have and possess and use the house if they want. They could rent it out. They could live in it, but they can't sell it until the notice is run. And the reason, like the conceptual reason behind that is, is it fair to the creditors for, if there was like a lot of debt and there's no money and all there is a house, is it fair for that house to be sold and like the beneficiaries get the money and not be subject to the creditor's claims? Does that make sense?
So the 2 daughters in this case could hold the house for 2 days or 2 years.
They could,
The estate would be closed and they could keep it and sell it
if you
then?
never opened up the estate and just held it for 2 years, then you could sell it after that point. Because it's kind of presumed that any creditor who really wants to come after it, the creditor can open up an estate as well. So a creditor, if they know the mom had this house and they have a large lien, some outstanding debt, then they can open up the estate to administer it to get themselves paid. So it's presumed that a creditor would have done that in 2 years.
Stepchildren.
Yes.
If you have stepchildren, you have to have a trust or will take care of it.
So I would just say, generally speaking, you don't have to have trust, but I would, if you want to leave something to them, then you must name them somehow. So it's got to be in the will or trust or beneficiary designation of some sort. Does that make sense? But you can't just, if you pass away with none of that, then your stepchildren will get nothing from you.
Question with regard to investment property
Yes.
owned by 2 different entities,
So
husband and wife
invest-
and other people.
Okay.
On the death of both the husband and wife, would it automatically go to beneficiaries if it was set up that way in the will?
Did you say that so it's like a husband and wife and other people and they have an LLC or not?
No.
No LLC?
What else?
So like, let's just say 4 people own it, a husband and wife, and then like 2 other owners?
Right.
Then, and what's your question, what happens to it?
What happens to it when the husband and wife owners pass away? Is their portion of that property simply go to the hands of the beneficiaries?
The beneficiaries or the other 2 people?
The beneficiaries. You own half of that property. The husband and wife own half of that property. The other 2 people own the other half.
Are the other 2 people their beneficiaries?
No.
They're not, they're just like friends?
Correct.
Okay. Then if husband and wife pass away, it would go to their beneficiaries, not the other co-owners. Typically, I mean, it's possible the deed could be worded such that it says that it, goes to the other owner, but I think that's more in other states. Like I know Tennessee does that. You can do like basically leave the property to a joint owner in a deed. Okay. That we do. And that, I would say the same thing goes for a business. Like I know someone who was like, my business partner just died and his daughter is like, you know, coming at me for half the business. And I'm like, yeah, it's hers, right? Like she's the sole heir.
Could you address a concept called living probate, advantages, disadvantages, and whatever else you might want to add?
Do you mean guardianship or do you mean like probating the will before you die?
The latter.
Probating the will before you die?
Yes.
I have not seen that done a whole lot, but obviously people, I think, do that in a situation where there are fighting beneficiaries or where you know, dad expects kids to fight over things. So it's just it's very rare. Do you have any experience with that, Jason?
Thank you. So generally, when we think about living probate, we probably think more of a guardianship connotation, where an individual, for whatever reason, is incapacitated or incompetent, disabled. Yeah, and now you're asking the court to step in to appoint someone to manage their financial state of affairs or make healthcare decisions for them. So if that's what you're talking about, and we're talking about more guardianship. Tell me the context that you're thinking of.
Somebody had just mentioned to me that if you want to get your will probated, you could do it before a judge, before you pass away. I mean, that's all I really know. I just would be interested in hearing advantages and disadvantages.
I don't think we've ever come across that, and I'm not sure what the advantages of that, to be quite candid.
I mean, I think the advantage is the testator is there to be whatever cross-examined or to appear in person to say, this is my true, you know, one last testament will. And I think, I mean, I guess the advantage is you're presenting that to the court in front of the court such that it will be very difficult. It does sound arduous and expensive.
Yeah, something to consider, and I don't know the answer. If you have a joint account and all the deposits and withdrawals are automatic, like the gas bill, electric bill, and pension checks, if one of the spouses dies, is that account frozen until the probate is over?
Not anymore. Thank goodness it's not like the 80s anymore. So if it's owned by spouses, they're basically automatically joined with right of survivorship. So that surviving spouse does get that account.
Okay.
If you will.
Thank you.
And all they really have to do is provide the death certificate, and they should take them off.
If you have trust accounts and something gets not included in those trust accounts, does that do anything to the trust accounts, or is it just the thing that you forgot in probate?
No, it doesn't do anything to the trust accounts, but yeah, we do see that, you know, one little asset, you know, one computer share account, one stock gets left out for whatever reason, and then we have to probate that one thing.
Right up here. And then we'll go over to Jim's side.
If someone's already got their will and a year or 2, 3 years down the road, they want to change it.
Yep.
Does it cost money to change like a donation or something about not giving to a person? I'd like you to speak a little bit to codicils, and I don't know, I want to know the advantage or if it's just easier to just add a sentence or leave a sentence in the will.
So the question is basically, does it cost money to do a codicil or to redo it if you want to change your will? Yes, because everything costs money. But as far as what to recommend, I mean, I think that's really a question for your estate planning attorney. I don't know that there's that much difference between a will with a codicil or just a brand new will. I mean, it's nice to have it all in one document. I will say our wills anyway, reference, I may leave a writing, like if it's just your tangible personal property, not real property, but if it's just, your furnishings and clothing and stuff like that, that can be, you can write on a separate piece of paper, sign and date it. You can tear it up if you want to change it and do a new one if you'd like. That tangible personal property can be easily changed. But if you're talking about like a share of the estate, like if the residuary estate, like 1/3, and I want to cut my daughter out, probably should think about doing it. I would just say any change in circumstance as far as assets or family, one of your beneficiaries passes away, the person you named as executor passes away, you move to a different state, you acquire new assets, you get rid of assets, you probably want to reevaluate your estate plan.
I had two questions. First one is, if I know of a creditor, but he never shows up to pull my money, am I obligated to tell the court that, oh, this creditor didn't show up?
So if you know of a creditor and then they never submitted a claim.
Right.
Okay,
that's
well, are they an ascertainable creditor? Like, was mom sick in the hospital and it's the hospital bill, but it didn't submit it? Like
somebody owes me for a car that they never paid me.
Oh, okay.
Or,
Then
I've never paid them. Am I even obligated to the court to say, hey, I didn't pay for this yet?
I think you're obligated by your own conscience
Okay,
and
that's just no.
And I would encourage you to do it.
The other question, this is a terrible process, and how does this, my estate will be very dynamic. It will be churning during this 3 years or whatever. How can you ever make an estimate of the final value? Things are coming in, payments, retirements, I'm paying my kids every month, that's the tougher maybe. Is there an answer to that?
Are you saying after you pass?
Yeah, after we both pass, and we got a will move.
Yep.
But the assets in the will are turning around. They're being money, they're investments, they're moving all over.
Well, what needs to happen in an estate is they need to all be marshaled and gathered together and accounted for and then dispersed, right? So, but you mean like in the interim?
Yeah,
Like
during the process.
You like you're getting dividends reinvested? Is that what you mean?
Well, everything changes.
You can get stock prices as of date of death, so that's your beginning inventory value. And then whatever comes in or out after that, just count it as a receipt or a disbursement. So you just have to track it all.
So it's a big accounting job is what I'm hearing.
Yes.
Lots of details.
Yeah, there's a program called Estate Val where they, like Edward Jones, I say, hey, this person died on this date, I need the estate val, and they run it as of that date, and then their account gets revalued, so the basis steps up as of that date of death, and then upon distribution or sale, there might be a realized gain or loss or unrealized gain or loss.
I think we spent our normal amount of time on questions. I'm just going to ask Jason to make some closing remarks, and then you're welcome to take the contact data for a follow-up.
Very quickly, I want to circle back on the question someone asked about, basically about a will from Texas. If you move from another state into North Carolina, our advice is that you always update that under North Carolina law. You're going to make it a heck of a lot more challenging for a probate process. You're going to slow the process. You're going to make it more expensive. So if you move into North Carolina, you moved here from a different state, probably should take the time to update that. Let me just say, guys, great questions. We certainly appreciate the opportunity to be here tonight. Jim, I want to thank you personally for inviting us here tonight. I hope our dialogue and our conversation has been useful. Avery is passing out some materials that we thought would be useful to you. If we can be a resource to you, please reach out to us. And again, I want to thank my colleague, Ashley Palmer. Ashley, do you have any final comments you would like to make?
Thank you so much for having us. I really enjoyed it, and I appreciate your questions, and I'll be in the back, at the front, or around if you want to ask me.
Yeah, if you have additional questions, please let us know.